Good afternoon, Chairs Miranda Williams, honorable members of the committee. My name is Joshua Dankoff, Director of Strategic Initiatives at Citizens for Juvenile Justice. Just to note, the word citizens for us means everyone. We represent and work on behalf of all young people in the Commonwealth, birth to 25. I've worked at CfJJ for 10 years. We're a nonprofit advocacy organization in the juvenile justice and child welfare space. I'm going to start with lesson 2 from Timothy Snyder's 2017 book on tyranny, 20 lessons from the 20th century. That is defend institutions. If an institution that helps, it is institutions that help us preserve decency. They need our help as well. Do not speak of our institutions unless you make them yours by acting on their behalf. What I'm asking you to do today is not just defend our immigrant neighbors, but also to defend the Massachusetts institutions that make up the juvenile justice and criminal justice systems from continuing to be co-opted by the federal authoritarian turn concerning treatment of immigrant children and youth. Why is CfJJ here today? Well, in May of this year, there were incidents in Chelsea where 5, 15, and 16-year-olds were arrested, and when they were at Chelsea police, they were taken directly from the police station into ICE custody. It's already discussed in Everett last month, a 13-year-old, again, arrested in police custody. His mother was there to pick him up, and he was taken directly from police custody to ICE custody.
Adult ICE custody.
He was actually taken pretty quickly out of state to a juvenile facility in Virginia, but he has since self-deported. I'm putting that in quotes because he is back in Brazil now, separated from his family. The questions that arise from that are, how did ICE learn that these children were in municipal custody? And then more broadly, and for you as legislators, what is and what should be the role of our state-level juvenile and criminal legal system actors, including municipal police, DAs, the courts, and county sheriffs, in collaborating and sharing information with ICE agents? For the last 2 months, I put in more than 60 public records requests to police agencies around the Commonwealth, all of the DA's office, all DA offices, all of the county sheriffs, specifically to understand what are their policies around communication and collaboration between the municipal and county level agencies and ICE, and what are the most recent examples of that communication. From what I've seen, the arrests and collaboration with ICE, the arrests that I just described, are not actually outliers. They're outliers in that they're children, but they're not outliers. They reflect the current gaps in Massachusetts law as articulated in police policies and practices that are very open to information sharing and collaboration. I'm going to talk about some of the specific examples in a couple minutes. So I'm not here to testify about the need to change federal immigration policies, though there is absolutely a strong need to do that. I'm going to give you some specific examples of what's happening and what you, the legislature, you have the power, the authority, and I'd argue the moral obligation to restrain, especially police collaboration with ICE, so that police and justice system actors for both children and adults do not result in the collaboration and information sharing that is ongoing right now. So I have 3 takeaway messages and 6 issues, time permitting.
Okay.
My first takeaway message is the current legal framework around police policies allows for collaboration and information sharing with ICE. And that undermines some of the core principles of both the juvenile and criminal legal system that have been discussed already today, namely the presumption of innocence, an opportunity to defend oneself, a right to an attorney, among others. So issue number 1, and there are a lot of things that you can do, but this is one you really got to do, is take on this fingerprinting process.
Say that again?
Fingerprinting process after arrest. So right now, for almost anyone arrested in Massachusetts for any crime, their information is very likely through the fingerprinting process going to be automatically shared with federal authorities, including ICE. Massachusetts law only requires police to fingerprint individuals arrested for felony offenses, but it allows, what we see now through policies is that most departments fingerprint both children and adults arrested for either misdemeanors or felony charges. And that is sent to the state police, the SIS, the state identification section of the state police, and then that is regularly submitted to ICE. This enables federal immigration enforcement to target the local individuals just by informing them of the person's location and criminal involvement. So the recommendation here is don't allow that to happen. You don't need to allow fingerprints to be taken unless it's specifically required by state law, and you can limit when that happens, right? There are bills currently in front of you now that would limit for juvenile fingerprints, even if they're taken and sent to the state police, it would limit sharing that with the FBI. That's House Bill 1695, Senate 1051, House 1657, Senate 1058. So you have an opportunity to fix that. And I would just say there's a lot of value in extending that as well to adults. The second issue has to do with police surveillance and information sharing. So the current policing infrastructure, as we've heard already in Massachusetts, includes significant surveillance regimes under the guise of the BRIC, the Boston Regional Intelligence Center, as well as the Massachusetts Fusion Center, run out of the state police. Just as an example, BPD and neighboring departments are member of BRIC, which includes also Department of Homeland Security, DHS, federal agent. There are federal police agents sitting in Boston Police Headquarters right now. And they have a policy that the BRIC is collecting a lot of surveillance information. They used to call it a gang database policy, but they are now call it the violent associative groups. And these, the policies that they're sharing and the information that they're sharing can and does go straight to ICE. And this is prior to arrest. This is just general surveillance information on individuals that can be and is shared with ICE. So the recommendation for the legislature would to be provide some guidance and guardrails around how that information is collected during surveillance, especially things that is not associated with a specific crime, and how that information gets shared with federal authorities. You could also take on and provide some guidance and limitation on what municipalities and municipal police departments do in terms of the ongoing federal task forces. There's an ICE/Homeland Security Investigations Task Force that we have municipal police departments participating in now, just as one example. The third issue, and the one that I mentioned before, has to do with policing policies. Many, though not all, police departments in Massachusetts have policies to give guidance to their officers around whether and how to communicate with ICE and whether and how to collaborate with them. Most of these policies do pay some lip service to protecting constitutional rights. Some of them mention the important Commonwealth versus Lunn Supreme Judicial Court decision, and they mention due process. But then if you read on, the substance of these policies really tell a different story. And many police departments have adopted policies that enable a wide range of police information sharing and collaboration with federal authorities. Some of these may go, if you read them, and I'm drafting a letter to the Attorney General's office to ask them to really consider whether the current policies are not in line with Lunn and not in line with existing state laws. But even the ones that don't violate state law right now, that's a problem, right? Our current laws allow extensive police and sheriff discretion concerning ICE information sharing and collaboration. I'm going to give examples from 4 municipalities. I'm not trying to single those out. There are many others, but I'm just going to give examples from 4. First, in Quincy, the Police General Order 3.08 that was updated this year requires its officers to conduct an INS immigration alien query whenever a foreign-born person is arrested. And it makes specific note that the results of this query are shared not just back with the department, but also with ICE. So anytime a person, including, there are many US citizens who are foreign-born, there are many legal permanent residents who are foreign-born. Anytime a foreign-born person is arrested, Quincy Police requires that the department do a check on their immigration status and then sends that automatically to ICE. That's happening right now. Quincy Police policy also directs officers to notify DHS ICE of bail determination in circumstances regarding pending release from custody. So it says, police officers, if this person is getting bail and they're leaving our custody, tell ICE about it. That's written in their policy right now. In Everett, and I went a little deeper in Everett because of the arrest last month, the Everett Police Department's enforcing immigration laws policy gives officers really wide discretion to decide when to cooperate with ICE. The language from the policy says that EPD can, quote, cooperate with ICE when it serves a public safety interest of the city of Everett, unquote. This language is very broad, does not define key terms like serious situation or public safety, or even what considers a threat. There are other words used here. And it basically gives individual police officers broad discretion to inquire into a person's immigration status and then collaborate. The word collaborate is there. Collaborate with ICE on that. Everett Police Policy also allows for citizenship and lawful resident status checks in a large range of situations. If anyone is arrested for any felony or misdemeanor or has questionable or no identification, that will trigger Everett Police to run an immigration check. EPD policy allows for the communication of location information to federal immigration authorities. They have these policies that says, we really support immigrants. And then just a long list. There are 6 exceptions to that in the Everett policy. If they come across a person who has been convicted of any felony, if they come across a person, if the Everett Police reasonably suspected or participating in criminal street gang activity. This goes back to the brick question. If a person has a warrant, either civil or criminal, that can trigger it.
Josh, can I ask one question? We're like sort of running on time. And I was just wondering if you could highlight the other few things so we can open it up for questions.
Absolutely.
Because I think if you submit, it looks like a very lengthy, feels like you're giving us a dissertation, which I love, giving that to us so we can actually peruse that. Because this is very alarming when you're thinking about children.
Indeed.
Right. Who we see as children.
Yeah.
Because when you talk about a 15-year-old or 13-year-old, if we believe that they were all children, we wouldn't be reacting in this way. But we look at some kids in the Commonwealth as children, and then we look at some of them as adults. And so you said you had a list of the 6. What number were you on? And could you just like top line highlight it for us?
Sure, I'll go very quickly then. It was already mentioned, don't allow more 287G agreements, but all of those policies that I mentioned just now, they don't have 287G agreements, and there's extensive collaboration. On the sheriff's side, all of the sheriff's departments are sharing information with ICE without a 287G agreement. This is documented in the press. I also have communications from some of the sheriffs. And one of the sheriffs, I spoke to him, and he said, well, the legislature doesn't require me to hold this back, and so I share. Basically asked you to put some limitations on it. So there's a lot going on in the jails that there's not time for. I will say the trial court has some issues going on. There's an important letter from the Lawyers for Civil Rights concerning the trial court issues and what's going on there. I understand separation of powers questions may cause some issues here. The last thing I'll say is be careful of the good immigrant, bad immigrant rhetoric, right? We see even from some of the highest levels of government here in Massachusetts, statements along the lines of, I support getting rid of the bad guys, getting the bad guys off the street. Everything that I've just talked about now, who gets to decide who a bad guy is? Mm-hmm. The 287G agreement with DOC, I personally don't think should be there, but the people involved there have gone through an entire criminal justice process. That's very different than the police officers just saying, oh, I think this is a bad guy, I'm going to notify ICE and basically cause their deportation. So that's my takeaway there.
Thank you so very much. We were just talking about surveillance, and I think the meat and potatoes of what you shared is around this idea of like, it's just like explicit bias versus implicit bias, right? Implicit bias trainings often don't work because there's a whole lot of explicit bias that we're trying to avoid or put a Band-Aid on. The same thing, we're trying to stop these 287G agreements and these other unique agreements, but what you just laid out is that there are dozens of informal, vigilante agreements where someone sitting either at a DOC facility, HOC facility, a court officer, somebody is working informally with ICE in a way that is as harmful or even more harmful than what a formal agreement would stipulate. And that's what I think I heard you say. And the second thing I heard you say, it's happening not only to adults, but it's happening to children. And many more than we are thinking about. So we've already seen the Everett case. We've seen what happened in Milford. You mentioned Everett and another town, but they're happening more often than we're actually getting the press to be able to share with us. Does anyone have any questions? Rep. Haven?
Thank you so much for your testimony. I just wanted to uplift your point around BRIC. And Rumeysa Öztürk was a tough student in Somerville who was abducted by ICE for an op-ed she wrote a year ago. And I wanted to just uplift, my understanding, and please if you could elaborate on this, with BRIC, the criteria to get into this so-called gang database, which is frankly not what it is anymore, can it include things like your religious views, whether you hold American family values or if you oppose capitalism or whatever your own political beliefs are, can trigger you to get into this database. And so just want to make sure I understand that that can then get shared with ICE as a way to target our constituents. Is that correct?
Yeah, the BRIC, the Boston Police Policy does not use those specific words.
Okay.
But there are a lot of generalities and a lot of subjectiveness in what's going on in the BRIC in terms of who is surveilled, and it does include some of the categories of what you're talking about. But absolutely, that information can and does get shared with ICE.
Thank you. Anyone else?
No.
If not, thank you so much, and please submit that testimony. It was really helpful to us, and I know for those of us in the Senate, with Response 2025, we just basically we're having a whole hearing here that I think could be very helpful in thinking about what recommendations we need to be very urgent, and simply put, whether it's a drafting of a letter, we do that often, or trying to double check on these guardrails, or to take other steps in the new year to make sure we're protecting the citizens of the Commonwealth. So thank you so much.